Well, thank you to everybody for joining us on this wonderful conference. We've had a very stimulating day, both the earlier discussions on the panels, and I think we're going to end up with, I think, the highest of the highlights, taking nothing away from the prior panels, because judges talking about judicial review seems a uniquely interesting and well-suited role for them to play. We are blessed to have three extremely distinguished jurists, former jurists, and great intellectual leaders of this field. I will not waste your time with the introductions to the people who literally need no introduction. I will simply hand it off to Judge Ulf Öberg, who will begin us with his remarks and start us on our discussion.
Thank you. It's both an honor and a privilege to be invited to this conference. Some habits do not tend to die. I mean, I used to be an advocate, so I'd rather stand if that's okay with you. I'll start with the first and obvious disclaimer, which I think is pretty pretentious one, that I do only pretend to speak for myself, not for the court or the general court. I used to be a lawyer, and I was trained in Swedish courts and EU courts to be rather clear in my public speaking. I'm also adapting a bit to my new functions as a judge, so that also means that I should be a little bit more measured. And the third one, speaking of a comparative law perspective, it's a third caveat, that my natural habitat is in the Swedish system, which is probably has more in common with the US system, the adversarial system, where the competition authority actually has to go to court and prove its case. Having that said, we'll actually expand a bit on that. From that perspective, obviously, as a judge or as a lawyer, the first question you would ask is, what's the legal provision to be interpreted? Is it clear? Is it subject to interpretation? Who has the burden of proof? What's the standard of proof? And what are the facts? And you take the facts and see where they lead you. In the EU perspective, it's a bit more complicated. It's a bit different. Obviously, it goes back to a large degree, French administrative law, where the starting point is not necessarily who has the burden of proof. Its starting point is what's the margin of discretion of the authority. Has the legislator entrusted the authority with a wide margin of discretion or a limited one? And depending on that question, the standard of review will vary. This brings me to my speech today, and I think that's an important distinction to be made in order to understand the various systems, which is, I'll try to provide an overview with recent case law on standards of judicial review, on complex economic assessments and the burden and standard of proof in EU competition cases. My first point is that the General Court is the EU judge of close examination of complex facts. Then we have to square that with the fact that we're doing a review of legality. It's the legality of an act and not the merits that we are supposed to review under the treaty. It's not possible for my court to substitute our own views on substance with that of the Commission. Could mean sometimes that there is some form of substitution of reasoning in some extent, but that's not what we're supposed to be doing. And this is, I think, where the whole problem starts, because there is a perception, there is a notion at least, that when it gets complicated, when there's a complex economic assessment, then the Commission necessarily has discretion to some extent, or at least our review is limited or confined to verifying the procedure, hence important for due process, statement of reasons, and whether there has been a manifest error. in assessment or the misuse of powers. So applying this traditional, and I stress this, traditional French approach, French administrative law approach, first question would be to say, well, are we in a field of a provision where the Commission has discretion? Because unless you answer that question, you don't know what the extent of judicial review is. Then secondly, it would be, well, what is complex? What is a complex economic assessment as compared to a simple one? Not everything that is an economic assessment can be complex, and I think there is quite a lot of case law saying, at least from the court, saying that, well, you should at least qualify why this is difficult from an economic perspective, why there might be different ways, different methods of reaching the conclusion. And thirdly, obviously, what is a manifest error test? One view would be to say, well, basically manifest error is what the judge says to be manifest error, and that doesn't lead you that far. I'm not completely convinced that this is the only way to look at the problem, but it's one that you need to have in the back of your mind when addressing the issue. Because there is a tension between, on the one hand, the review legality under Article 263 of the treaty on the one hand, and the rules of the burden of proof in Regulation 1/2003, where it's for the Commission to prove basically that there's been infringement. So what do you do when a defendant comes before the court? The defendant before the Commission becomes the plaintiff before the court. How do you manipulate the rules and burden of proof and standard of proof? What about the presumption of innocence, for example? It is true, I think that's a fair assessment, at least of the case law in the past, that when faced with economic reasoning or evidence of general technical, economic, political, and certain times even legal complexity, the courts have taken a step back. I think the counterexample to this is the IKEA case of the court in an anti-dumping case, saying that basically if it's legally complex, the judicial review should be limited, which to me is questionable. The fact that it's legally difficult doesn't mean that the judge should step back. That's possibly when we should take a step forward. To the defense of the French administrative law notion is also that the manifest error principle or assessment, erreur manifeste d'appréciation, is probably in its European version quite misunderstood. Normally, as far as I understand French administrative law, having studied in France, this is especially applicable to the assessment of facts. There is no such thing, as far as I've understood in French, as a manifest error in law. Either there's an error of law or there isn't. There's not a degree to the error of law to which the administration or the institutions are held. And I think that point is made really clearly in the report, and I thank you for that, because that is a misunderstanding. There is a full review of questions of law by the General Court. Since its establishment back in '88, the whole raison d'être, the whole mission statement of the General Court was to improve the protection of individual interests. In particular, in proceedings necessitating close examination of complex facts in order to maintain quality and effectiveness of judicial review. That's in the very decision that created the General Court. This has been recalled quite recently in a judgment in November by the Grand Chamber of the Court in a state aid case, C-13516 Georg Marienhütte, which says basically that the action of annulment is a particularly appropriate procedural framework for a thorough examination by both parties being heard, notion of contradictory procedure, of legal and factual questions, in particular in technical and complex fields such as state aid. It cannot be stated more clearly by the court that there's a thorough examination to be made, at least in state aid cases. You will find more or less the same reasoning in the Gulp case. It's a case C603 for 13, where the court has more or less the same reasoning as regards 101 and 102 cases. Subject to in-depth review by the general court in law and fact in the light of the pleas raised by the applicants. It also adds, based on previous case law, I think it's Knaus Gibbs, that the general court is allowed to take into account all the elements submitted by the applicant, whether they predate or post-date the decision, whether they were introduced in the file or they are new, in the context of proceedings before the general court. So the door is open to provide evidence to those who wish to do so. And then it has to be done timely, obviously, under the rules of procedure of the court. We have spoken a lot about perception today, and I think perception is important. There is a perception that the General Court has moved from being a specialized competition court to a more general administrative court, and that we are not exercising the same discipline on the Commission as used to be the case in earlier days. If you look at the statistics, and obviously numbers count, there has been a drop in cases in competition cases. There are many explanations to this, one being obviously decentralization, another one being commitments, less decisions to be reviewed. But obviously the numbers have gone down in recent years. Listening to my former colleagues from the bar, there is also a perception, why go to the court, why go to the general court if it gets complicated? Basically, the standard we have to meet is so high that there's basically no point of litigating the case. I don't know whether there's any truth to that proposition. Looking at the numbers, and I've looked more to the different categories of state aid merger cases. Merger cases, obviously, 8% are being annulled, 46 are rejection. The figure that I think, or that worries me, is the cases that basically are dismissed or withdrawn for some reason. Expediency, takes too long to get an answer, etc., etc. More half of the cases that reach the docket do not reach the stage of a judgment. In state aid cases, the annulation rate is 14%. Here, the big issue is one of admissibility. It's the cases that we don't hear, it's a third of the cases. And I would like also to point out a recent development in the case Maria Montessori, which were given last week or 2 weeks ago by the General Court on the conditions of admissibility in state aid cases and possibility to bring action as competitors, where I think the Grand Chamber of the Court has opened the door to our court. Hardcore competition cases. Well, obviously, the number of cases before our court depends on the number of cases before the Commission. Of 83 Commission decisions, 38 were appealed, 19 partially annulled by the General Court. Those figures, obviously, you will have to dig deeper into the figures to see on what grounds was the annulation. But it says something, 15 cases under appeal. Fines, if you look at this, and this is credit due to Mark van der Woude, who has taken this on a more quantitative approach. If you look at it, of the billion of euros of fines, 30 billions, 19 contested, 8.8 subject to a judicial review. Final amount of fines 6.2, annulled 2.4, and we have a portfolio of undecided cases of 10 billion or 11 billion euros. So obviously something is going on before the General Court. Outcome of actions, obviously they are going down, number of appeals are also going up. That might be an issue of some concern. If you look at statistics of the General Court, more and more of the competition, the state aid cases are being appealed, so the parties are not content with the judgments of the General Court. And this brings me, and I will conclude on that point, to a couple of questions. When faced with complexity, what should the judges do? There is here somewhat of a law of unintended consequences. The whole notion of a more economic approach, an approach based on more of an economic analysis at the outset, I believe was at least presented as a way to limit the role of judges. It's the Bork article on judges acting as philosopher kings. Well, the problem is that when that theory is applied to the European setting, what that means is obviously that the Commission, when applying economic theory, if you stick with the fact that if it's complex, we take a step back, that means that the Commission's powers in having economic assessments are less checked by judges, basically. That's what you get at the outset. Judge De Cruz Vilasa, in a recent piece on the notion of intensive judicial review and complex economic assessment, finished this piece in saying economic science is as neutral as a machine gun. Both will answer to those who know how to handle them. I think this is a fair point. If we don't know how to handle economic reasoning, economic facts, economic evidence, well, obviously, then we might be in trouble. What do we do as judges? Well, obviously, it depends on the parties. Depends on how the parties want to bring the case to us. The more complex the cases are, obviously there's a trade-off to be made between addressing that complexity in a commission decision and trying to convince the judge. What if the judge doesn't understand? It's obviously a risk to be taken. Should we, as judges, more rely on expert opinions? Should there be more specialization? To my mind, basically, I would contend that we need to return to a more judiciary and evidential review of economic facts, element of proof theories presented before us. I think that is how judges and how lawyers resolve those questions. I'm very much in favor of simplicity in the face of complexity. Let's try to make more things a little bit more simple, but we can't do it alone. We're very much dependent on how judges or how the parties present cases to us. 3 pieces of advice for anybody appearing before our court. The usual: be precise, concise, concentrate on your strongest arguments. You know, the more complicated your case is, the longer it's going to take, and the more fuzzy the solution may be. Kill your darlings. Obviously, as lawyers, there is a difficulty to be perceived as weak. I don't perceive weakness if you give up on certain arguments, certain grounds, certain facts, which just will not fly. That helps judges. That is, to my mind, a sign of strength, not a weakness. And be honest. If the case law is not clear, please tell us so, and please tell us why it should be clarified. If there is a precedent, and I think we have a lot to learn from the British tradition of barristers, if there's a precedent actually that is not in your favor, well, say so and try to distinguish the case. I think that is something that would be very, very useful to judges at the General Court. And thirdly, I cannot stress enough what Mark van der Woude and also Ian has said. Anticipate reasonable confidentiality requests. We spend a lot of time on that and trying to find solution to make that speedier. I am hoping to be able to provide a more collaborative, hands-on approach on the cases in partnership with the parties and having a real-time instruction of cases. It's going to take time because that is not how things are usually done at the General Court. So I think change is incremental. Thank you so much.
Thank you, Judge Öberg, for some very fascinating remarks. At this point, I will turn the podium over to Nicholas Forwood, who speaks from many different perspectives, all of which we will benefit from today.
Thank you, Christopher. Well, thank you first for the invitation to be present on this occasion and indeed on this panel. I think that the project on which you are engaged is an extremely important one. I mean, I think we all have a lot to learn from our different systems, and the answers as to what is the best result in each system will not necessarily be the same in all cases, but that doesn't preclude the importance and helpfulness of knowing what is happening elsewhere. And in that spirit, I thought that I could most helpfully contribute in this panel by offering a series of thoughts, some of which are inspired by the fact that previous speakers have given me a hospital pass, as they call it in rugby terms, you know, where you get the ball and then everyone jumps on top of you. Some of the thoughts are also based on my own experience while I was at the General Court. I think one important point that's struck me in listening to the discussions this morning is still how very different particularly the US and the EU procedures are, not merely in terms of procedure, but also in terms of the nature of the evidence on which the agency brings its proceedings or seeks to rely, whether it's the DOJ bringing a prosecution in the before the district court or the state attorneys general and so on, or the commission here. The commission proceedings here are almost exclusively based on written evidence, what has been documents that have been discovered in the possession of the parties or by market surveys or the various methods, with an enormous distrust of oral evidence, particularly post hoc oral explanation. By contrast, oral evidence and witness evidence is right at the heart of US enforcement. I was told, last week I was in Washington and was told by a practitioner there of a current case, I think it is, where it had emerged that the proof of the leading witness for the prosecution in the case had gone through 34 drafts as it eventually emerged, and which that very fact indicated how important that oral evidence is seen to be. Now, that obviously has enormous implications, therefore, for access to the file, and I think that we've reached, by and large, subject to problems of confidentiality, I think a fairly good position so far as the Commission is concerned. I'm not too concerned about that. The second point that I made is that, by and large, the Commission needs essentially to identify in its decision the documents on which it is relying. There is a certain amount of flexibility, but part of the reasoning that is required of the Commission in its decisions is to indicate what evidence it's relying on in support of which factual conclusions are set out in the decision. That, of course, is greatly facilitated now by the numbering of documents, and you see endless documents in the footnotes and so on, but that at least simplifies the task of the court. Now, third, someone observed that procedural questions are still a major focus of the General Court. I think that is certainly true. How far that is effectively driven by the concern of the difficulty of some of the factual issues that are presented, or how far it is the result of the last point that I'm going to mention at this stage, I don't know. But that last point, and that's something that has been touched on, is that we are still, I think, in a state of transition. Menarini was in, was it 13, 12? I can't remember, but certainly this decade. And the corresponding Chalcor and other cases that have stressed the need for a full review. To a certain extent, I think that prior to the statement of that need for a full review, there was an unwillingness of lawyers in deciding which issues to advance before the General Court, and it's already been touched on, this difficulty of choosing which are the points you want to focus on. There is a real problem, I think, a very difficult task that lawyers have when presented with a decision of deciding how in your 2 months and 10 days you are going to identify the issues on which you want to fight before the court. But here there are various procedural constraints. The court itself, the General Court, says in principle you should limit your application to 50 pages. There is still a risk that if you go over, even in the context of a 300-page decision, if you go over 100 pages, then you may be asked to cut that back. And the mere fact of the prospect of possibly being asked to cut that back is a bit of a disincentive. And I do worry from time to time that the tightness of that rule is discouraging even the taking of, or the ability to develop points that could usefully be developed in an application. There is the risk then, or then the problem that I then see of the virtuous or vicious circle in respect of what the advocate, when drafting the application and deciding on the rules, deciding on the grounds, expects from the way the court can respond. And I think one particular problem at the moment, as I said, we're in this sort of stage of transition where Galp has reminded us that even in principle you can introduce new arguments and new evidence before the court that were not before the Commission, that may or may not be present problems in your effectively asked, why didn't you present this earlier? Well, we thought what we'd given the Commission was enough and they should have accepted that, but they haven't, so here's some more. That's something that may even be more possible in relation to economic evidence than it is in relation to factual issues. So that brings me on now to this question of how the court deals with economic evidence and issues. Now, there is a clear line of case law which refers to the court's, the General Court's limited role in relation to questions involving complex economic assessment. I remember some 10 years ago we had a similar discussion about this issue, I think in the EUI in Florence. And I then made the point that, in my view, one mustn't confuse a complex economic assessment with a difficult economic assessment, rather echoing the point made about difficult questions of law nonetheless. To a certain extent, there are issues such as does the balance of advantage of a particular agreement when applying 1013 in terms of benefits to the user and so on as against the restriction of competition. That, in my view, is a good example of a complex assessment in the sense that it involves a balancing of what I call apples and oranges. And provided that the facts are accurately found, then the question of whether a certain assessment of benefits to users is sufficient to be justified by, or to justify the restriction of competition that's been identified earlier, is the sort of assessment where one should hold back. On the other hand, assessments that go to, for example, defining what is the relevant market, or as to the probable consequences of a particular course of conduct in terms of trying to identify a theory of harm, don't involve that sort of complexity of assessment. One has to remember, too, that prior to 2004, the first category of assessment that I mentioned, the 103 assessment, was one that was entrusted to the Commission and the Commission alone. There was indeed controversy at the time that the idea that national judges could be entrusted with this balancing test. But the fact is that we're now in a situation where, even in relation to 1013, in the same way that national judges can be expected to say, well, this is something that a judge can do, I see no reason in principle why the General Court should not, subject perhaps to the true 1013 point, be expected to exercise any restraint in relation to market definition, power on the market, or questions of that. Not least in the Menarini context, but I would say even independently of that, which is the idea that there should be this full review. So I believe that from that point of view, it should be possible for the court to carry out this full review. But the question which now arises is, how do we either break out of the vicious circle that lawyers will be reluctant to present these complex issues, if that's the right label for them, these difficult economic questions to the court, in the absence of certainty as to how they will be treated, or perhaps in the presence of uncertainty as to how they will be treated. To a certain extent, of course, the Galp case and the other ones that have been mentioned, where the court has stressed that the full review that's envisaged for the General Court includes the willingness to receive new evidence and new arguments, carries with it, it seems to me, the inevitable logical consequence that whenever such new evidence is put forward on an issue, there can be no place at all for any deference to the decision of the administration, because by definition, the decision that the court is presented with is on the basis of different material from that was before the decision maker. This, in fact, of course, creates a different situation, and in my view, a quite important difference of situation between state aid and merger cases on the one hand and infringement cases on the other. And there are various other differences between state aid and merger cases and infringement cases, not least the fact that state aid and merger cases are essentially looking at likely future effects and all the problems that they create, whereas the issue in infringement cases is what happened in the past, what were the effects in the past. So there is to a certain extent, I think one of the Advocates General pointed out, these are essentially very different types of assessment, and where a more rigorous approach can be justified as a matter of principle. So that said, therefore, I think that the groundwork should be there for a closer review and a perceived willingness of the General Court to review even these so-called complex economic assessments and to, so to speak, get its hands dirty with some of these issues. But, of course, the question then is, how do they do this? Now, some of you may know that way back in the 1990s, the Court of First Instance, as it then was, indeed engaged an economist to assist the judges in relation to those cases which involved significant elements of argument on economic analysis. Unfortunately, he found he actually had very little to do. And the result was, I think after 2 or 3 years, his contract was terminated. But that, of course, was at a time when the climate, it was pre the trio of merger cases which have been referred to earlier, prior to the appointment of a chief economist and the chief economist service within DG Comp, and prior to, in general terms, the more economic approach. Of course, there is some concern that the court having its own in some form or other, whether on a permanent basis or appointing as in a model that's more familiar to continental judges, where a judge may appoint an independent expert to assist them on various issues. There is then the concern that the economist used to help the court becomes a substitute for the judge. And that is a real concern. But in my view, it's one that can be managed. And in a situation where one has competing arguments about economic theory, whether there's econometric evidence and the correct basis for it, whether it's application of one or other principle, it seems to me that there is room for a role for an economist advising the judges, not to tell them what the answer is, but to help them, if necessary, with to identify where the real issues and differences are between the two opinions, and to say, well, on the one hand, on that issue, that is the common point on which they disagree. They agree that those are the points on which they disagree, and the way through may be to look at this rather than that, but it's your decision. But in effect, to help them, particularly in circumstances where you have competing economic theories. So that it seems to me is one particular area where, in some manner, and I leave it to the court to decide, where, if you like, some indication of a willingness to be open to that possibility is something that could then encourage these issues to be litigated, where I fear sometimes the decision may be taken not to advance it, not because it's not thought to be a good argument, but because there is this uncertainty as to how the issue will be dealt with. I think, yes, that broadly exhausts my comments so far. I'm happy to come back later, but I think from now over to Doug.
Thank you very much, Sir. This is a wonderful presentation. And now we are blessed with an encore presentation from Judge Douglas Ginsburg of the U.S. Court of Appeals for the D.C. Circuit.
Thank you, Christopher. Earlier today, you mentioned, Christopher, at the outset, the Tunney Act, under which consent agreements reached by the Antitrust Division of the Department of Justice and a defendant in a civil antitrust matter must be placed before a court, asking the court to embody the agreement in a judgment of the court, a consent judgment. And the act obliges that court to give public notice and hold the matter for, I think, 60 days to receive public comment. You said you thought the act had been adjudged a failure. I can only elaborate that it's been judged a miserable failure or a complete failure. I set out to do some empirical work on this a couple of years ago. What I found was that all but a handful of matters attracted 0 public comment. And those matters, those few, attracted a very large number, often 1,500 or so, public comments. They were all identical postcards, all sent in by, say, union members or trade association members, and added nothing whatever. That's not unfortunate because there's real doubt as to whether the act is constitutional. The idea that a court could pass judgment on a decision of the executive branch essentially not to prosecute a case or not to further prosecute it, is a very questionable practice under the separation of powers. Thus far, we've avoided having to resolve that. The few appeals that there have been have led my court, in the District of Columbia Federal Court of Appeals, to say that the review by us and by the district court is extraordinarily deferential. So we're thinking that this issue will never be joined as a constitutional matter, and that the whole thing is a waste of everyone's time, a paper shuffle, and a burden and cost. Nothing to show for it. All right, so the question of judicial review I don't think can be fully addressed without considering what agencies do in order either to anticipate or, more interestingly, to avoid judicial review. There have been, one hopes that their adaptation would be solely to anticipate by bulletproofing their decisions with complete evidence, irrefutable theories and inferences, and I suppose that they tried to do that. But even better is to avoid judicial review from the agency's point of view. And so more than 90%, I think it might be 97%, of all of the cases opened by the Federal Trade Commission and the Antitrust Division over the last decade or two decades have been settled, entering into either consent decrees entered into by the Justice Department in a court, or agreements entered by the Federal Trade Commission without court supervision, comparable to what are termed commitments decisions in Europe. My colleague Joshua Wright and I have written 2 articles about these, the first one being an empirical piece on the content and consequences of this practice. It's called The Culture of Consent. And one of the things that we find is that we think it entices agencies to identify the low-hanging fruit, the cases that will be easily settled, that will notch up victories, and that will maybe even signal to the business community what the agency thinks of some practice, all at a very low cost and not great time commitment. Comparably, I think the litigation capacity of the agencies withers when they go to court only a few times a year and handle, say, 3 cases in court and 97 in chambers without having to go to court. Most troubling, and this was true primarily in some of the US states and in some of the member states, were commitment decisions that were facially anti-competitive and could probably not have been obtained by relief in court. Examples include agreements, for instance, by a hospital in a merger case, not to employ more than X% of all the physicians in the surrounding jurisdiction, the county in the US or what have you. I think there's one in the Netherlands to that effect as well. It might be also a commitment to make a monetary contribution to the support of some program favored by the executive. We have a case in Utah in the US in which the governor had set up some sort of health care program involving nurses and some staff in his office, and the parties agreed to fund it for a period of years as a condition of their merger, completely unrelated to whatever competition issue may have been raised in the first place. Similarly, there are 2 Federal Trade Commission decisions, and I think there's something comparable, but I'm not sure on the continent, in which parties have been, I would say, extorted to agree that they will not seek injunctions to enforce their standard essential patents anywhere in the world as a condition of a merger, admittedly in a case in which there was a substantial portfolio of patents on one side of the merger, not the other, so it was not a competition issue at all. It's not as if these portfolios were substitutes, or indeed that there were two portfolios. These are things that occur, yes, in the shadow of the law, but in the dark shadow of the law, because they'll never see the light of day, or at least they'll never get into a court. So it is a problem. And at the same time, what can one say? You should go litigate matters on which you've agreed? Well, if the agreement is illegitimate, yes, it shouldn't be entered into. But if it's a legitimate agreement, and of course the majority are, the great majority are, it's hard to say one shouldn't, that the agency shouldn't enter into these arrangements. Professor Wish, when he was at his retirement ceremony, I think it was at King's, said he wished he knew the law on various subjects relating to platform markets and so on, but because of commitment decisions, he fears he'll never know. And that is a problem, much more so for the business community than for we professors. Now, relating all this back to the due process, it does seem to me that review of the economic rationale for a competition decision, meaningful review by a court that understands the economics, is an essential element of due process. There's a drawing many years ago in a New Yorker magazine of a courtroom in which the judge and all of the jurors are kangaroos. I don't think that court would be capable of due process. Likewise, a court of ignorant judges, ignorant of the economics that's being discussed before them, are not able to do any more than either hide under the shadow, hide under the standard of review in favor of the agency, or toss a coin, which I don't think they do. So we see in the report references to recent decisions in the three relevant jurisdictions, two in China, Johnson & Johnson and Kehoe, which are model decisions, really superb, coming a few years ago in each case, and representing a real understanding of the economics and application of the law. In one instance, I understand hearsay, only once removed, that the judge went across town in Beijing, taking God knows how many subways, to get to a library where he knew there was a treatise put out by the American Bar Association that dealt with the issues, the issue in the case, and consulted that, and it may have aided his analysis, but it was a very good opinion. In the EU, it was the UPS case that's highlighted, and in the US, it's just said that the review of the economic theory and evidence is most of the three searching. A fair statement, I think. Now, within the US, we have, of course, two agencies, one on the administrative model, one on the prosecutorial model, the FTC and the Department of Justice, respectively. And the Federal Trade Commission has in its portfolio an internal hearing procedure, one administrative law judge who conducts the hearings. And over a 20-year period, the administrative law judge disagreed in some part with the charges brought by the commission in something approaching 50% of the cases, often one charge out of several, sometimes the only charge or all of them, but was uniformly set to right by the commission itself, vindicating its own judgment in having brought the case in the first place. Now, it nonetheless, as the report says, then is in turn reversed in 50% of the cases that are appealed. Now, there's a strong selection bias in terms of which ones are appealed. They're the ones that are fragile in counsel's judgment, and there should be some substantial rate of appeal, but it is much higher than it is for a court of first instance hearing a case brought by the Department of Justice. The district court that hears that case is unlikely to be reversed more than 20% of the time. So we have a pretty stark example here of the way in which these two operate. Now, in terms of the economic capacity of the forum and of the judges and commissioners involved. Are they up to it? We have some outstanding examples, like the ones mentioned from the other jurisdictions, in which a district court, first instance court, has done a superb job really digging into the economics involved in the case. And a merger example was the Oracle PeopleSoft acquisition, which was tried in San Francisco and the government lost. Another one is the Moderator decision in the Third Circuit, which is a vertical restraints case. Again, the Court of Appeals in that case got deeply into the economics, and it's widely regarded as a decision vindicating the view that the judges are up to it. Well, of course, it does vary somewhat with the cases. The district judges in particular are out there on their own, one judge, typically hearing from two experts contradicting each other on every point or every important point that's litigated. So what are they to do? Few of them have ever studied economics. If they have, it's a course they had in college, one course a long time ago. They're overwhelmingly people whose first degree was in the liberal arts, political science, history, literature, and so on. Few have even studied a technical subject in mathematics or science. In 2014, I moved from New York University to George Mason University, having pitched the dean that I wanted to create the Global Antitrust Institute to teach judges and regulatory staff, agency staff, economics relevant to competition cases. As I said then, I thought there was a great need that I could observe, but I could not say whether there was any demand. It's turned out there is a substantial demand, and we've been giving 3 or 4 week-long courses each year around the world for judges and regulators. Some judicial education is demonstrably helpful. The one empirical study done by my colleague Josh Wright, and Michael Bay, who was chief economist at one of the agencies in the past, found that judges who had gone through the course, or a course like this, had a much lower chance of a reversal when dealing with modest and relative, less complicated and relative and intermediately complicated cases. When it came to very complicated cases, they did not do better. Those cases are not that common. Those are the uncommon Section 2 cases in the US comparable to 102 here. There just aren't that many of them. So the judges materially improve their performance in competition cases if they do this. Another adaptation is specialization in the courts. And specialization can be a matter of degree. A court can have a narrow specialty in competition, as the CCI did the tribunal did in India, but it was now reorganized to take into account company law and other matters. It could be relatively narrow, such as the CAT in the UK, with competition and regulatory matters. It could be broader, such as the business courts in, I think maybe Sweden, and certainly in Eastern Europe in a few cases there are so-called business courts that include competition matters. And Brazil is now contemplating whether to have a court for competition and international commerce being put together. And then there's opinion specialization within a court of general jurisdiction, a phenomenon that's been studied empirically a few times. It's not all that uncommon. I understand that it occurs within the general court, that there are a chamber of judges at any one time who take the competition cases. And presumably, one hopes, and undoubtedly, since the experiment goes on, they do acquire a familiarity with the field that it makes them more efficient and expert in adjudicating the cases. Now, this is, I think, extremely important when one considers that we are now, at least in the US and I think increasingly here, encountering economic experts in every significant case and even cartel cases. and in some cases, 3 stages in the litigation. The first stage being in the US, and now increasingly here, the class certification, where you have economics experts testifying about the commonality of the damage to the various members of the alleged class. Or I should say the alleged damages. The class is about to be certified. Yeah, it's still the alleged class. Again, at the merits or liability stage, and then finally in the damages phase. So it's becoming pervasive in the litigation. And to the extent that there are now collective redress actions in the EU, I think this is already starting to emerge, thanks in no small part to Michael Hausfeld, who I'm happy to say is the one plaintiff's representative on our advisory committee at the Global Antitrust Institute. So it's going to be a field dominated by, or at least permeated by, economics, and it does seem a shame to have it tried or appealed before judges who have never seen a competition case before, or they've seen one every so often and never done any economics. And in the US, and I would wager in some member states as well, where there are not specialist tribunals, that some judges will encounter a competition case once in a career. That's not uncommon in the US. It's totally uncommon that the judges do get recurring experience in San Francisco, Chicago, and New York, where these cases are brought so frequently, but not in other jurisdictions within the country, other forums. So I'm a great proponent of that. I think it's important in order to have an engaged and informed judiciary hearing competition cases. The lawyers recognize it. They're either engaging the experts or having experts advise them on the content of their briefs. And I think it's equally important that we and our colleagues on the bench take the same steps. Thank you.
Thank you, Judge Ginsburg, and thanks to all the panelists for 3 excellent presentations. This is the stage of the panel where we open it to the floor for comments and questions. If you would, raise your hand. Anyone who would like to share a question with the panel?
I have one.
Please.
For Nicholas. So is it possible then, maybe it's happened, that a party would go to the general court raising only new issues and essentially inducing the court to act as a first instance court in some respect, even though it's coming from the agency, from the commission?
To my knowledge, it's not happened yet. A long time ago, I was one of the very junior counsel for IBM in the 1980s when a man called Colin Öberg was in charge of the case at the commission level, and they sent their statement of objections. IBM, after we'd all worked very hard for 6 months, put in the response to the statement of objections, which was pretty thick. And Colin Öberg said, well, I don't know why you've bothered. Why didn't you just say, we disagree, see you in court? So at that stage, there was a perception that was a viable course. I think what has happened until, I say, about 2010, was the perception that you couldn't be guaranteed that when you got to court, if you were to take that line, you would say, well, why didn't you raise this argument earlier? And are you even allowed to raise this argument earlier? And indeed, in the general context, and I made the distinction earlier between true administrative cases and the competition cases, the general principle is, certainly at least so far as evidence is concerned, the issue for the court is whether the decision maker took the right decision on the basis of the evidence before it. And on that basis, you clearly can't run the risk. I think the real interesting question now is the extent to which what's been said in Galp about new arguments and new evidence can really change that basis, even in theory. I say in theory because in practice, I still think in most cases, anyone advising a company in the situation of IBM will say, no, you put in at least most of your arguments now and don't necessarily hold anything back. Whether, if that fails, you might then reflect on whether there is any further evidence you want to put in. And I think this may be particularly significant in relation to economic evidence. Then that possibility may be open. And indeed, there's in fact, going back to my past, a long, long time ago, I represented the Commission in a case called Hilti, which was an Article 102, as it now is, case about nail guns. And the question was about market definition. Were these fixing systems involving shooting a nail into a piece of concrete in the same market as fixing systems that involved drilling a hole and then hitting it in with a hammer or a screw? And the market definition had been disputed before the Commission. There was evidence put in. And then when Hilti challenged the decision taken against it, it also introduced a new econometric study which had been carried out in the, I think that the data was just before the decision had been taken and the analysis was just after, saying, look, you can see cross-price elasticity between the two fixing systems and therefore they should be in the same market. That gave rise to a question of principle. Should the Commission object to that on the basis that it was not before the decision taker? And in fact, for various reasons of long discussion, but the objection was not taken and it was decided to address the issue on its merits. But that was a fairly rare example, but perhaps it's an illustration of the sort of situation in which new evidence can credibly be put in. You know, you've had one go. Obviously, there is some evidence which will significantly lose credibility if it's not presented in the course of the administrative procedure. But I think there is also a category of situations, I think the Hilti case is a good example, where it may be useful and overall positive to seek to do so. And that then gives rise to the question of, well, could the General Court, or the Court of First Instance as it then was, have exercised any judicial deference to the Commission's assessment of market, bearing in mind there's now this new evidence?
We have an absolute rule against relying on anything that was not in the record.
Yes.
But, and likewise, the agency may not justify its decision on the basis of a rationale that was not in the decision. Mm-hmm. So there's a parity there. But but clear error versus error, if the matter is coming from a court and not from the agency, we have a distinction between error and clear error. If the objection was not raised in the first instance, it will not be considered unless the error was clear, meaning the judge should have raised it himself or herself because the law was clear.
It's fascinating because I know Judge Öberg was interested in this. He was asking me about U.S. practice in this regard during one of the breaks. But this is where I'm fascinated by your framing it, Judge Öberg, in terms of French administrative law. Because there's two considerations about why you would insist on not allowing it to be brought in the court. One is a matter of pure judicial economy, which is if you have an issue, you'd like to have you'd like to have one good litigation. And in many cases, if you don't bring it, it's waived. You know, that you would create rules like that have nothing to do with the larger question of competence, but more just about how you want to structure decision making. But in the US system, there's a very distinctive flavor from the progressive era roots of administrative law, where in the 1920s and the New Deal era, we believed really strongly in expertise. And there's a flavor of the decisions that you want, because of the composition, the expert composition of the agencies, you want them deciding it in the first instance. One of the reasons that you insist that it be decided at the highest levels of the agencies is they're the ones that wield the expertise and are structured in that way. And that affects, to some extent, the doctrine you're talking about, Chenery, the reliance on the decisions under US decision making, that in addition to a judicial economy, that there's some virtue from an institutional standpoint having it handled by the agency instead of the courts.
There's a non-utilitarian answer as well. Yep. The legislature assigned that
Correct.
to the agency, not to the court.
And what I find myself wondering is the French model really the question of where the legislature assigned the responsibility? And is there any room in European law for this notion of wanting the so-called experts to be the first instance decision makers because of the nature of their backgrounds?
A lot of issues there. I mean, on introducing new evidence, obviously, we have rules of procedures which allows it. So on a black letter law application of rules of procedure, we wouldn't have a chapter on evidence if it wasn't possible. We have clear evidence it's possible, but there is still obviously the notion of a control of legality of the decision when it was taken. Was that correct then? I believe that the courts are starting to tweak with that a little bit, saying it's not only what was before the administrative body, but what could have been before it. It's a duty to investigate. You can't just turn a blind eye if it was possible to actually have material proof to one way or the other, and then I would suspect, that would be definitely admissible before our court, and we would have to review it. You would have to frame it differently, possibly, but if there is evidence that came up later, well, to my mind, yes, it is admissible. I'm not saying that the French model is the one that always prevails, but you have to have it in the backdrop of understanding the system and the review of legality as such. But then you will have to square that with rules of the burden of proof. I used to clerk for Judge Ragneman back in the 90s. I think we had the same discussion then in the Baustallgewerbe case, where the whole discussion also was about the Menarini issue, the presumption of innocence, to what evidentiary standards do you hold the commission? On the area of law, obviously, there is a difference between the first instance and what issues can be raised on appeal if you haven't raised it before the general court, unless it's au public. I would suspect that it is not admissible to raise it on appeal. I think there's clear case law to that. On the notion of clear areas of law and less clear ones, I think the way we deal with it is that some areas of law will lead to an annulment of the decision, and some will not. There's still an error of law. You can't have a small error of law. It's on the consequence of the validity of the decision. Or clerical errors. I've never, in my 2 years here at the court, seen so many clerical errors. 15 years in Sweden, never saw a clerical error. We do tend to say it's a clerical error, it's an erreur de plume, it's a simple formal error. I'll write a piece on that at some point, and we kind of distinguish the real errors with from the bigger ones. There was one question you had which I kind of lost.
So I'd asked about whether you're doing it out of judicial economy or trying to defer expertise to the agency because of their institutional competence.
I can't speak for the past. I think there was a time where the docket of the General Court and Court of First Instance was pretty swamped. And I think you have to respect that. That could, to some extent, explain the manifest error standard or the complex economic assessment standard. There's one point I want to make on due process. I'm all for it, but not on the expense of actually examining the case on its merits. There is a tendency sometime to find a formal error, and that, for judicial expediency, if you can get rid of the case on that basis, you don't have to deal with complexity. So, I would tread a little bit carefully of just over-stressing the due process and the procedural issues at the expense of actually having a review on the substance matter, which I think is, the reason, at least why I am here today.
Cleo.
Actually, while we were on the topic of arguments heard for the first time before the General Court, I thought about settling parties appealing settlements. There have not been that many cases, but Société Générale, I think, withdrew their appeal, but Printio's appeal was heard. And I was wondering that the fact that the General Court is confronted with new argument for the first time is perhaps showing a flaw in the settlement procedure process, because those arguments are related to whether the fine imposed on the settling party is proportionate compared to fines imposed on other parties. Throughout the settlement procedure, you only have bilateral discussion with the Commission, so you know what kind of objections are raised against you, and you have a range of the fine that will be imposed on you at the end, but you don't know where you are relative to other parties. You can only know that when the decision is appealed, is adopted, and at this stage, all you can do is launch an action for annulment.
Yes, well, I think you're right. That is an interesting example of a situation where you can't be expected to advance the argument because you aren't in possession of the relevant facts until after the decision has been taken and the discrimination or lack of proportionality or however it's analysed isn't apparent until you have the evidence.
So it kind of made me think about what we discussed earlier this morning, is whether this is an indication that perhaps settlement in general would deserve to have a bit of judicial review, scrutiny
Yes.
at some stage.
Yes, possibly.
So we've reached almost the end. I would like to ask one question in closing, since we've had our audience been very patient with us on a very fulfilling but a longish day. The question that's most interesting to me as one of the authors of the report is the future of the manifest error standard under EU law. There arguably are some signs in the cases of moving away to engage in more scrutiny, but it remains black letter law in terms of precedent. I would love and really welcome your opinions as to whether the courts will engage in more searching scrutiny of economic analysis and that will continue on that trend, or if you think that the manifest error abuse of power standard will remain as previously stated.
Well, as to whether it will, I can only say I think I would like to see the manifest error test largely disappear. And in part, as I indicated earlier, that's because the issues where it is frequently applied are issues of fact which can equally arise before ordinary civil judges in the context of ordinary damages claims for infringement of the competition rules, whether it's market definition, whether it's abuse, whether it's the consequences, whether it's the theory of harm, whichever of these aspects where it is said manifest error should be the level of control. I find it difficult in principle to justify the General Court, the Court of Justice of the European Union, applying or failing to apply a standard and a judicial approach which is expected of every national judge before which a non-follow-on claim is brought alleging infringement of the competition rules. So there being no reason in principle why the court could not do so, I find it then particularly hard to justify why that margin should be allowed, bearing in mind also the problems that have been identified earlier about the procedure as it stands. The situation might be different if the decision-making procedure before the Commission resembled something more like the administrative law judge, a fully independent agency. I remember Giuliano Marenco, who was one of the members of the Commission's legal service, who frequently used to say that he felt that it would be right that the Commission should really move away and have a full independent decision-making agency, rather similar to the administrative law judge, for infringement cases. And in that situation, then I can see a greater argument for the General Court then acting rather like an appellate court and applying a manifest error sort of approach with a sort of presumption in favour. But so long as, despite the no doubt, and I agree, considerable advance that the Commission has taken in improving its internal procedures in many areas, there are still these underlying problems which John Temple Lang, amongst others, identified today. And in that situation, it seems to me, you cannot then justify not doing something that any national judge is expected to be capable of doing. That's the way I think about it.
Judge Öberg, any thoughts?
I think I'll have to tread carefully on this one. I think the court has moved past manifest error standard in state aid cases, in 101, 102 cases. I think it still depends. For a notion whether there is state aid or not, that's an objective notion. I don't think there is room within the qualification for a manifest error standard. On the other hand, when you come to compatibility, well, then obviously the Commission has discretion, and that's where the manifest error standard has its place. In 101 cases, you could have basically the same view. Whether there's dominance, whether there's been an abuse, I don't think there's that much room for a manifest error standard. On a 101.3, well, obviously there is discretion, and I think the judge should take a step back. So my answer is a bit complex. I think the court has moved past it, but don't listen to what judges say. Look at what they do.
Any closing thoughts, Judge Ginsburg?
That was very succinct, the last statement there. I think that's, I think I'm not saying anything specific to the European courts, but courts generally are much more inclined to change the content of the terms rather than change the terms, and do so gradually. It's nuanced. It may not even be self-conscious. It will be observed retrospectively by outsiders.
Well, as one of those outsiders who enjoys observing what courts do, please join me in thanking what was a very stimulating panel. And it is, my last task of the day is to close the sessions here. And I want to thank all the speakers who've been fantastic in their support for this project, but in their interest in it. They've given us the most sincere form of flattery, which is engaging it in a detailed manner and give it their attention and their input and their thought. And for that, we are truly grateful. As any scholar will tell you, there are many people who agree with me, there's many people who disagree with me. The worst case scenario is that for them to ignore me. So, I mean, we're deeply flattered by your interest in the project. I would love to thank Professor Fetzer and Professor Huang for being collaborators on what we think has been a very fruitful endeavor to this point, and we expect to continue to be, and to thank Hendrik Wendland and Louis Capozzi, who's been helping us with the project. And we really do invite you to stay involved in this conversation. Among other things, Judge Ginsburg pointed out to me yesterday, I just forgot to mention, the Antitrust Chronicle of Competition Policy International, their November 2018 issue, is devoted entirely to due process. This is, as I said, being geared up in a number of forums and is likely to be an issue that has continuing legacy, and we are probably likely to continue to do events in and around this issue on all three jurisdictions going into the future. We invite you to collaborate, to continue to have this conversation with us on this and the big data analytics and algorithmic project we're launching on from here. And with that, I declare this session adjourned.